I'm Rick Poulson. I'm the executive director of LRIS, and welcome everybody to this kind of fun little version of the monthly podcast. If you're listening on the podcast and you missed it live, oh well, it's okay. We still love you. This month, we're going to talk about public employee speech in the wake of the Charlie Kirk assassination. That's why we're doing this as a special edition. You guys know, you've seen, stuff going crazy all over the media, all over social media. Not just about like just the horrible murder of Charlie Kirk, but the aftermath, right? And all of the kind of social media battles that we've seen, and the blowback in the workforce of people losing their jobs. And so, as we know that when Kirk was killed on September 10th, that set off a wave of people commenting on it. On social media, and a related wave of disciplinary actions all across the country against workers of all sorts, right, who commented or who posted critical or even celebratory comments, online about the Kirk murder. And, look, on this podcast, we talk about public employees. And for public employees, the rules are very different for folks who work in the private sector. And that's because the First Amendment puts very real limits on what government employers can do in response to public employee speech. Now, since about 1968, in the Supreme Court, in its decision in Pickering versus Board of Education, we'll talk about that a little more this hour, has required a balance. And basically, we're going to balance the public employee's right to speak as a private citizen about matters of public concern against the government's interest in running an efficient workplace. And sometimes I chuckle when I say government, workplace, and efficient all in the same sentence, but that's okay, right? But we're going to balance the employee's right to say what they want to say versus the government's right to run a workplace. And we do want the government to run an efficient workplace. So what does that balance mean? That balance means a lot of the time that outrage alone is not going to be enough to justify discipline. And that's what the standard will be. And that's going to frame this coming wave of Charlie Kirk discipline cases. And I promise you, there will be a wave of Charlie Kirk discipline cases. I was reading an article today, 150 reported incidents out there of people losing their jobs because of things they posted on social media. Bunch of lawsuits already filed. I saw a federal district court in South Dakota, I think earlier this week, stepped in and issued a TRO preventing a university from suspending a professor who made some pretty vile statements, quite frankly, about the Kirk assassination. But we're seeing it left and right. And so what are we going to do here? On this episode, we're going to try to talk about what are the standards. And we're going to talk about actually 6 recent cases, 3 kind of from like within the last year, and then 3 that were decided last month. I mean, these are like, they were right in a row over the course of a week that are dead on, and they are public safety, public employee folks posting stuff on social media and being disciplined. So, we know how the courts look at these things. So we're going to try to talk about those cases and make some predictions, or try to identify maybe some best practices moving forward on how we can protect people, or how maybe we can get people out of a jam, if they posted something stupid about the Charlie Kirk assassination. And so I'm not smart enough to do it all on my own. So I'm going to be joined this month, as you guys can see, by a special guest, Jessica Caggiano. Hi, Jessica. Jessica's a partner at the Philadelphia labor law firm of Willig, Williams, and Davidson, where Jessica works with private and public sector clients across a really wide range of industry. She's a very interesting practice. One of those clients is Philadelphia's police, FOP Lodge 5 in Philadelphia. And in that capacity, Jessica has handled many, many, many cases involving police officers posting things on social media and being disciplined. And so she's developed a bit of an expertise in that area. She's a frequent LRIS speaker, and she speaks on this. And she's actually going to be speaking on this exact stuff, public employee speech rights, in November at our discipline seminar in Las Vegas. That'll be a fun one if you want to come out. Boy, that was a long intro. Hi, Jess. Welcome to the podcast.
Hi, Rick. Happy to be here.
Thanks so much for joining me. And somebody should know what they're talking about on this. So we have a 50% success rate for sure on the pod. You've never been on the podcast before, I don't think.
I have not. This is very exciting for me.
Okay, good. Let's give a little bit of background, maybe, if you could kind of tell folks a little bit about yourself and your practice.
Well, as you noted, I represent both private and public sector workers through the unions I represent now at the firm at Willig, Williams and Davidson, including FOP Lodge 5. I also have, in addition to representing other public sector workers, both law enforcement and non-law enforcement, I represent professional athletes. So I have a sports labor law practice, and I also represent other private sector workers in a variety of industries. But prior to coming to the firm, I represented public sector workers almost exclusively. Mm-hmm. So in my time as a lawyer, I represented tons of different public sector employees working for the state of New York, all across the state in various capacities. And prior to that, teachers and support staff at schools, custodial workers, school nurses, everyone you can think of working almost exclusively in the public sector, working for the state teachers union here in Pennsylvania prior to that. So my practice has always been public sector workers and their issues, of which the First Amendment is, front and center for a lot of them, and comes up in a lot of different ways, including in some of our labor arbitrations, as you noted in your intro.
Yeah, we're going to talk about one of those, actually. Well, several of those in the context of one of our cases today. And
right.
And I spy a Portland document on the wall behind you? Is that correct? What do we have there?
You do. I have a Portland Thorns football club scarf up on the wall behind me. I don't have. I represent all the players in the NWSL Players Association through my representation of the union as its counsel. Outside labor counsel and also counsel to the union just in general now as an outhouse attorney. But love the Thorns, have had the privilege of going to some of their games and others in the past. And so, really excited. We do cool work, right?
You do cool work. It's fun. That's gotta be fun. And I love the term outhouse attorney. And so I feel like one very often. Okay. So let's talk about some of these. Oh, and I think just for people who are, there's a lot of people. All right. So for the many people who are with us, you can comment. And so go ahead and comment on stuff. If you have any questions, if you disagree with what we're saying, we'll try to get you answers in real time. If you have questions that don't relate to the cases, I don't care. Just submit the questions and, we'll see if we can get you answers. And if you don't have questions, that's also okay. But we're going to talk about cases. And so going to talk about a little bit of background, and there's two cases that I want to mention from the U.S. Supreme Court. I would say that over the last 50 years, there's probably like 15 or so Supreme Court cases of consequence related to speech in the workplace or public employee speech in the workplace, maybe more than like 10, I don't know. But the biggie is Pickering versus Board of Education. And, when we talk about these cases at LRIS seminars, I always call this one the original social media case. And this is a teacher case, right? And there are a lot of teacher cases that are going to be coming down the pike in the wake of Charlie Kirk. And we'll talk a little bit about that. And so it's important to keep that in mind. So this guy, Marvin Pickering, is a teacher, high school teacher it's like suburban Chicago school district. And the district, there was like a ballot question or a referendum on a tax increase. And I'm not sure what the process was there, but they had to go to the voters to increase taxes, maybe probably like a bond issue or something. And they were holding out, well, we need to invest in education. And here's why we need you got taxpayers to pay more. And what they were going to do was build a football field, they were going to build, which is important, right? They were going to invest in their sports facilities. And so this guy's a teacher and he writes a letter to the editor, basically saying this is all bullshit and they're just going to spend it on sports and we need books and pencils and we have to pay our teachers. And, if you want to read the letter or the excerpts from the letter, you can just Google it. You can go to the Supreme Court webpage and find all that information. So I am paraphrasing Mr. Pickering's letter, but it's critical of the school district. What happens in response to that? The school district is horrified that somebody would have the temerity, an employee no less, to criticize their decisions, right? They have an inherent right to mismanage their operations after all, right? And so Pickering writes this letter and they fire him. Basically, that's the bottom line. They fire him. He appeals through the state. There's kind of a civil service-y type system where he appeals and he loses. He takes that case up to the Illinois Supreme Court where he loses, and the case makes its way up to the U.S. Supreme Court. And that's where we get this test. And Pickering won. And the Supreme Court basically said that he had a right, to say what he wanted to say. Just because, when you took that job in the public sector, it didn't mean that you gave away all your constitutional rights. But it also means you can't say whatever the hell you want, whenever the hell you want. So how are we going to figure out what to do? The court gave us a balancing test. This is what courts love to do. This is why courts exist, to balance things, right? My rights versus yours, your rights versus mine. And what's the test? So on one side, there's a couple of preliminary questions the court wants to ask. One is, was the person speaking as a private citizen, right? Not as a teacher, but speaking as a citizen. Were they speaking about a matter of public concern, right? As opposed to some kind of private gripe, about the workplace, something that people care about. If those two things are accurate, a court is going to balance the employee's right to say what they had to say versus the government's right to avoid disruption, right? To run an efficient workplace. In that particular case, viewing those facts, the court determined that the balancing test favored Marvin Pickering, who was reinstated. But the important thing, for us is that's the test. That Pickering balancing test is the rule of the road. It's been the rule of the road for 50 years, and it's probably not changing. And so whenever these Charlie Kirk cases or, whatever else is next down the line cases come up, courts are still using that balancing test. One other case, Supreme Court case I want to mention before we talk about some of the recent ones is a 1987 case, Rankin v. McPherson. This is it's one of the 10 biggies. It's not like the biggest Supreme Court case on public employee speech, but the facts are interesting and they're relevant, right, to this. And so Rankin v. McPherson involves a constable's office in Texas, and involves the plaintiff in that case was she was new. She was like 19-year-old clerk. Her name was Ardith McPherson. And so she was technically a deputy constable, but I think everybody held that job title. She was really a clerk in the office. And she was working in 1981 on the day that President Reagan was shot, right? So we have an assassination attempt on the president. It comes over the radio. Everyone's listening to this news. I remember, actually, I'm so old that I actually remember I was sitting in my kitchen. I remember being on the TV. I remember the news. It was a big, big, big deal. And Ardith, 19-year-old Ardith says, well, if they go for him again, I hope they get him. Probably not the nicest thing to say. And it didn't make her the most popular employee in the office that day. And in fact, one of the supervisors overheard what she said, told the constable fires her. Boom. She's done that day. Get out of here. And that was Constable Rankin, who fired her. We're a law enforcement agency. We're not going to stand for that kind of stuff. You're gone. She sued for wrongful termination. And the question really was, could she make this type of politically charged, kind of intemperate, comment about a matter of public concern? And she lost, first couple rungs of the ladder, but the case made its way up to the Supreme Court, and Ardith won in the Supreme Court. And so her kind of offensive remark about an assassination attempt on the president of the United States was protected, right? Because it touched on public policy. And the court noted when they applied the Pickering balancing test that this comment didn't interfere with the efficiency of the workplace. It didn't disrupt how the constable's office worked. And so, she had a right to say what she said, and it didn't really interfere with the job of the constable's office. There's a couple interesting quotes from the case, from the majority. The inappropriate, and just think about this in terms of what people are saying today and what some of the people posted and probably continue to post about Charlie Kirk. Quote, the inappropriate or controversial character of a statement is irrelevant to the question whether it deals with a matter of public concern. Debate on public issues should be uninhibited, robust, and wide open, and may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. Right, so that has to be allowed, right, even for public employees. The majority went on, to say that in this particular case, the undisputed evidence showed that McPherson made a, quote, ill-considered but protected comment during a private conversation. Ding, 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 private conversation. All right, we're talking about social media. All right, so remember that. During a private conversation And the constable made an instinctive but intemperate decision to fire because he didn't like what she said. Right? That's why I fired her, not because it interrupted with work. He didn't like her opinion, and that's why he fired her. Interesting dissent in that case. Justice Scalia always has an interesting dissent, and usually the best written, whether you agree with it or not. The guy could write. Interesting quote here. No law enforcement agency is required by the First Amendment to permit one of its employees to, quote, ride with the cops and cheer for the robbers. Right? I mean, and that's, I hear where he's coming from there. But ultimately, the Rankin case, it does stand for this proposition that, you do get to comment on matters of public concern. And it's the inoffensive stuff isn't a problem, right? We're not talking about that. It's the offensive stuff that needs protection. Now, I have a couple of, comments here, about Rankin before we jump into these other cases, and think about what if Rankin were a constable? What if this was a local police department in Texas and Rankin was a police officer and not a clerk? Would that make a difference? I would suggest to you probably yes, it would have made a difference. And what if Rankin McPherson, as opposed to making a statement in the office to somebody else that somebody happened to overhear, made that very same statement, but did it on social media to her 100 Facebook friends? Would that have made a difference? Yeah, I think it would have. And what if somebody was actually looking for an excuse to jam somebody up for criticizing the assassination of President Reagan and demanded her discharge and sent it around to 1 million people? Would that make a difference? Yes, it would make a difference. And so, we have these cases and these facts that set standards, but, technology changes and our politics change, and it'll be interesting to see how these standards apply as we move forward. Now, all right, that's old history. That's back from the 80s. My mullet in the 80s was awesome. Jessica, probably, I don't even want to know what you were doing in the 80s. Do not answer the question.
I mean, I'll give you a hint. I wasn't doing anything for a good part of the 80s.
Yeah, that's what I thought. Yeah. That sucks. All right. So, all right. We're going to talk about some more recent cases, and there's actually a pretty interesting speech case. Now we're going to apply this stuff to social media and more current events and see how these standards hold up. We've got this Noble case from the Sixth Circuit. Is that right?
Yep, that's right. Noble versus Cincinnati and Hamilton County Public Library came out in August of 2024 out of the Sixth Circuit. And this is a really good case to segue into after talking about Rankin v. McPherson and the table setting and the questions that Rick just posed, which are foreshadowing as we work through these cases, right? Really? So Noble was involved in a public library security guard out of Ohio who, was terminated for an off-duty posting of a meme. Okay, we're going to talk about the specifics of that and how it came out. But essentially, we've fast forwarded in time now. It's not the 1980s. We're not commenting anymore about President Reagan and attempted assassination attempts. This case and a couple of other cases we're going to talk about, they are coming in the wake of, the killing of George Floyd and people posting in the wake of that killing and the protests and sort of a lot of different opinions both ways and in the middle, and a lot of people sharing because now it's 2024. And when we share, we're sharing on social media for the most part. We're not just making comments to coworkers in real time. So what did Noble do? What did he actually post? So he shared a meme, right? Most of you probably know what memes are. So he didn't create this. It's a picture of a car, and it's hitting some stick figure people. And it said at the top of it, "All lives splatter." And underneath it said, "No one cares about your protest." So he shares this meme while he's at home, not on duty, on his Facebook page. And the court found it relevant. So I'm going to share with you because I think a lot of the courts find it relevant, right? What were his settings? So and how did things look up? He did identify himself as a library employee on Facebook, but he didn't have many friends. He had about 50 to 100. And the court took note of the fact that of those Facebook friends he had, less than a half a dozen were coworkers. Mm-hmm. And I think otherwise, his comments were sort of confined to the audience that he had, which was a fairly limited audience. And the other fact, that was relevant to the court's decision, so we're going to mention it, is so he posted this meme and he took it down within 24 hours because mommy, called him up and told him that it wasn't a very good idea. And the court at one point, I think, says, he very wisely listened to his mother. And as a mother myself, I can say, I just hope my children listen to me someday when I tell them inevitably to take things off of social media.
So he's probably in the basement, right? He's in the bed, who knows? And he posts this thing. And, Marvin Pickering wrote a letter to the editor, right? He typed it out. He wrote it out, or he probably revised it and drafted it and had to send it. And, there's a lot of effort there as opposed to me being in the basement on my phone. I see a meme and bloop, real quick. Right. And so there's people aren't giving a lot of thought to what they're posting, online, I don't think. And I don't think there was a lot here. All right. So we post it and some of his coworkers see it. And what happens?
Yes. In less than that 24 hours, coworkers see it. They're the ones that go to the library and say, hey, this is not okay. And an important factor for the court here, right, was the library itself had a political leaning, and it wasn't keeping that hidden. They had put on the library's own Facebook page, I think something supportive of the Black Lives Matter movement, and the protests were going on at that point. So the court found it relevant, right, in terms of looking at, was this really disruptive, or did you just not like the quality of the speech or the viewpoint of the speech that one of your employees was making? So anyways, how does it all turn out? Well, the library terminates Noble. They basically give him two reasons. They say it violates their harassment policy that they have, because coworkers of his saw this and obviously were upset and reported it to the employer.
Yeah. And
they note that they have a loss of confidence in his ability to perform his duties impartially. And I think they also said, it had more to do with them having a loss of confidence in his ability to wield his authority properly as the security guard, right? Almost
as a library security, like keeping the mean streets of the, geography section safe. Like what? I mean, like,
right. The restricted section of the library. I don't know, but
God bless him, right? I mean, it's all jobs, dignity, but like, come on. We're concerned that he'll be able to secure the library.
Right. Apparently that, somehow the meme and the quality of it. There was even a discussion in the case about, whether he drove often for work, on work duty, because the meme he had posted involved, the suggestion that, stick figure protesters. Right. But the court says, look, that even the employer is not seriously making the argument that they think he's sincere in what he's suggesting in the meme. So anyway, he gets fired. He sues under the First Amendment. He ultimately wins before the Sixth Circuit Court of Appeals. And the court found that he was speaking on a matter of public concern. And to your point, Rick, about, I guess, the quality of the speech, right? In terms of like, he's just quickly sharing this meme that who knows who created this, as opposed to, Mr. Pickering, who's typing up this like letter, taking all this time to revise and putting it in the local paper.
Yeah.
It matters, I think, to courts a little bit, but it's not supposed to be about whether your speech is sophisticated or whether it's deemed, worthwhile, or like it will really benefit the public, right? So his speech, of course, is ultimately, it's on a matter of public concern.
Yeah.
And it meets that first step of the test. And he obviously wasn't making it on duty or in the context of his role as a security guard. So he's speaking as a private citizen at home, at home on his own time on his phone. But of course, then we go to the balancing test, which is, where a lot of these cases end up and where the rubber really hits the road. The court here, emphasized that it was one meme and that it was up for less than 24 hours and cited the lack of evidence from the employer of public backlash, or that this post would somehow significantly disrupt their operations or potentially disrupt their operations. I think they used the words, I'm paraphrasing a little, all this did was wound the feelings of a few coworkers. I think they used the words.
That's exactly right.
Feelings. Yeah. And they didn't seem to feel like that was, such a disruption or any kind of a disruption that could possibly outweigh the speech here.
I wonder about that. Like, so, because I mean, my take from the case was that this guy, like, so the thing that he posted, which is just like, I don't like protests either. You know what I mean? And it doesn't mean I'm going to run people over. Yeah. And like some of the stuff, some things are offensive. Some things are like funny, but they're not fun. Like, it's just a stupid meme. They're unlike some of the other memes that we're going to talk about, which are just flat out offensive, but this one was a little less offensive. But his coworkers didn't like it. His boss, they were marching those protests, right? So clearly, like, he had the minority opinion, is my guess, in that library. And I wonder, if they would have worked that up a little more, how that could have disrupted the workplace, right? If people were like, I'm not going to work with him anymore, or I'm not going to, and factually, could the employer have developed that in a way that might have, helped kind of tip the scales more towards them? And we see that in some of these other cases, and we're going to see that in Charlie Kirk cases. So if you've got, in a conservative part of the country, a firefighter or a police officer posting something critical of Charlie Kirk, and the other 60 people in the department are like, dude, you're a dick. We're really offended by that. What happened? We don't want to work with you anymore. Like, is that disruption? And the answer is it's going to depend on the judge and the lawyers and how you can develop it. But yeah, I wonder about that in this case, because the court really, did basically say, you just didn't like it. That's why you fired him.
Right. That's exactly what they said.
And this has got the cancel line, right? This is
the
one where,
some good, I was just going to say, there's a good quote from the court. There's no evidence that Noble took his politics to work, or that his views on the BLM protests or any other political matter ever interfered with how he performed his job. The First Amendment does not permit one side of a debate to use the government to cancel the other side. It allows all perspectives, even the very offensive, to be heard. Yeah,
right. I mean, that how the majority feels about cancel culture, I think from that statement, and cancel goes both ways, right? All depends on who's being canceled, right, and what the point of view is. But that's one. All right, so we got 6 cases. That's one for the employee, right? Mr. Noble wins. Now the next case you are a little closer to than the Noble case. Just tell us about this one.
Sure. So we're going to talk about Finico versus City of Philadelphia. It's a series of cases. It started in the Eastern District of Pennsylvania, went up to the Third Circuit, came back down. So this case, and it's also not just about Mr. Finico. There were 20 different plaintiffs. They were all Philadelphia police officers, which is why I'm very familiar with the facts of these cases, as I tried the labor arbitrations of maybe not all of the officers that were involved as plaintiffs, but a good chunk of them. Yeah. And their posts were at issue in the underlying cases, the same as, that they were the basis upon which the officers were saying, I was fired in retaliation for First Amendment speech in this case. So you've got 20 plaintiffs and hundreds of posts because, of course, this case came out of the Plainview Project, which was a project a few years back where, this group called Injustice Watch took the time to search Facebook records they picked a couple of different cities, including Philadelphia, and they took the time to see who identified as a Philadelphia police officer, whether current or retired, and they went back through their posts. They screenshotted the ones that they felt were concerning, and they had their own litmus test for what was concerning. And they also said they didn't know whether the posts were protected or not. They were highlighting them, whether they were protected or not, because they concerned them. So there's this database online now, right, Rick? Plainview Project?
If you go, you can Google Plainview Project and see it. The website's still up. They stopped adding to it. And look, they made no bones about what their goal was. And if you go back to the beginning of it, I think the woman's name was Emily Baker White, who did work on it. And she was a law student. She was at Yale, I think, and she was doing a clerkship in Philadelphia in the defender's office, and she was preparing to cross-examine people. And so a lot of the people, we talk about Brady and Giglio issues on the podcast a lot, and so she was basically a clerk doing background research to help the lawyer she was working with cross-examine police officers. And what she was doing was finding them on social media. Give me the name, let me go find them. And she was finding all kinds of crazy stuff that people were posting, offensive stuff that could be Brady Giglio material. And so she did her job, and that was fair game. Somehow that transformed with a lot of money coming from some organ. I have no idea, but somebody got the idea. Let's scale this up, go nationwide, and let's get rid of cops. Let's get rid of racist cops. Basically, is the idea. We're going to find them on social media. We're going to expose them, and let the chips fall where they may. And on I think the Injustice Watch website, I mean they proudly report we got X number of police officers fired, et cetera. And so, that's the kind of thing that's out there. And we're seeing the opposite of that. And actually, let me think about, like, I've been thinking about this in working up to this thing that we're doing today, this month's podcast. It almost seemed quaint, the Plainview Project. This was back in 2018. It's not that far ago, but it may as well be 1,000,000 years ago in terms of how strategy changes or how political action changes, or even things on social media change. They did it like the old school way. You got to credit the job they did. The website is really thorough. It's unbelievable, the job that they did. Unfortunately, terrible motives, but it's a well done website. They had the website. They did a press release and they tried to get attention to the website and the project. And there was a big story in the New York Times and in like the local papers in the towns, and then like, let's see what happens. And a lot of people lost their jobs because of that. And that's like the old school way of doing it, right? Now, if you take that same thing, and whether it's like Libs of TikTok or what other organizations are out there, they're doing the same thing with like Charlie Kirk. They're not like doing a report and saying, okay, whatever happens, happens, right? These are sophisticated, well-funded campaigns to find people, to out them, to dox them, to identify them, and then to demand that they get fired. It's like 2018, like it seems like people were so much nicer back then. I don't know, but it's a very different world.
Pre-pandemic, we might have been nicer. Who knows?
Yeah, it was pre-pandemic. Maybe it's COVID. This is like some form of COVID that's made everybody meaner, I think. Maybe it was the vaccines. Oh, wait. I don't know. All right, let's continue. What happened with this stuff? So these guys get fired. Let's do a side note. The union grieved and challenged these, and the outcomes were mostly successful, right?
Yeah. Yes, they were largely successful. Although, I will say not necessarily because of the First Amendment concerns, right? Yeah. But more to do with, how similar discipline matters had been handled in the past, and basically arbitrators being uncomfortable with people being made an example of when the manner in which this happened. These posts were being sort of extracted. You might have made a comment years before. It's being used against you now. You don't even remember what you were talking about, whether circumstances have changed over time. So I think there was a lack of comfort with, collecting all of these different bits of speech and then hitting people over the head with them later.
Yeah.
And in addition to the fact that it was obvious that the city was reacting, as many employers would, to the media storm and the public outrage that came with the very public, publication of the database. And once that got out there, everyone could look through it and everybody felt a certain way.
But you're not supposed to have what the courts will call a heckler's veto, where you can shout things down just because you don't like it and get people disciplined. But that's kind of what happened there. But, for it, just to be specific, there were several grievances, individual grievances filed in connection with officers who were terminated. And this happened in other cities too, where the overwhelming majority of those officers were reinstated using traditional just cause principles, and disparate treatment was one of those big arguments. And that's, I think, a valid point to remember, to keep in mind for listeners of, it's very interesting to talk about these First Amendment things. And oftentimes you'll have an employee who's disciplined and has just cause protections, and also may have statutory rights, independent rights that they own, and they might pursue a lawsuit. It's very difficult to win those lawsuits, and it takes a lot of time and money, and a lot of times you're just better off going the grievance route. And it's just something to keep in mind. There are different ways to go. Now these guys here, though, notwithstanding our own personal opinions about, the cases they're terminated, they raised their First Amendment argument. It gets sent down to, it goes up to the circuit court, gets sent back to the district court, and the judge applies the balancing test. And how'd that turn out?
Well, the Third Circuit had basically said, and given the lower court instructions, right, it was uncomfortable with how hastily the Eastern District dismissed the case in the first instance. And they basically didn't say, they weren't sanctioning the speech, saying it was good or great, or they liked it one way or another, but they were like, look, you can't just paint it all with one broad brush and say it has no value. We don't have to even look into the facts of disruption. We're just going to assume that it's so disruptive that there could be no value to it that could overcome that disruption. They said, you got to do a little bit more. So when it went back down, there was a little bit of discovery that had to occur on the disruption piece. And while a lot of the speech was in fact speech made as private citizens on matters of public concern, ultimately though, the lower court says we've got enough of a factual basis now that we've done discovery here to say that, that there was disruption, or at least a reasonable likelihood of disruption, right? Yeah. It damaged, we find a reasonable likelihood of disruption to the relationship between the police department and the community based on the public response here. We believe that there's been enough of a showing that it undermined officers' credibility as witnesses in criminal trials, to your earlier point, Rick. Yep. And that it created, there was a reasonable belief, or there was enough evidence to suggest that it created tension and distrust within the police department itself. So kind of what we were talking about in the Noble case, where the coworkers were upset about the speech. That piece was here as well, although I think it was, not the primary piece. It was the damage to the relationship with the community that was, I think, the piece that they found most.
Yeah, I think so. Yeah, and police departments are different, right? If this were the library, it might be different. Okay, it might be a different outcome. I'm going to ask you a question I haven't talked about with you. Do you know how many pages the judge's decision was at the district court?
The lower district court one?
Yeah.
Was that the?
I'll give you an over-under. I'll give you the over-under. 200 is the over-under.
I was going to say, wasn't it like 250 some pages? Was it
298 page decision? Wow. So how do you think the judge felt about this case? Every single post was like, oh, you want me to go through it? I'm going to go through it, and I'm not going to change my mind. And that's, sometimes when an appellate court kicks it back, that's what you get back. And so I think one of the things in that case that the back and forth between the appellate court and the district court was this issue of disruption, on the government side of things. And, sometimes you see like actual disruption versus like the likelihood of disruption. And I think that employers often will short circuit their investigation, and just the faster the employer acts, I think the more problematic it's going to be for them. And we've actually seen a lot of that with Charlie Kirk, where they just say, well, this kind of stuff, interferes with our ability to, be the government. And you can't do that. Now, you don't need to prove it. You don't need to prove that the government failed as a result of the statement, but you can't just wave a wand and say, oh, I think mere speculation, isn't enough. You see that in all the cases. So the question is, how are you going to lay out the degree to which your operations were disrupted? And I think something to bear in mind is that, one of the things the court's going to consider is like, what type of a department is this? Is it a police department? And if it's a police department, they're going to give the government the benefit of the doubt. And so, all right, that's that one. Let's go to the next case, number 3. So far, it's workers 1, employers 1. This is Brown versus City of Tulsa is the next case. And let me click on that banner. All righty. This is from January of this year, and this is out of the 10th Circuit. So we have, I think we had an 8th Circuit decision. We got a 6th Circuit decision. We had a 3rd Circuit decision. We've got now a 10th Circuit decision. So we're covering lots of different parts of the country. This is based in Tulsa. This is a Tulsa police officer. So we have a police officer fired for Facebook posts. The posts were made before he was employed, right? Didn't make him as a police officer. So makes it through, gets hired, and then somebody, right? I don't know, who knows, right? There's always somebody looking to screw you. And so somebody finds this guy's, Facebook post, And I love the description in the case. He's got a picture of Donald Trump riding a lion, which I'm assuming is a drawing and not an actual lion. I don't have any evidence that he wrote on a squished lion. A Blue Lives Matter flag, like that one behind, like, all right, what's offensive about that? And then a photo of the American flag with the words, "I will fight to my last breath before I submit to Islam." Okay, we're getting a little closer to police officers' bias. These are giglio things, that can be problematic. And but those are the 3 posts, and they make the mayor aware of it. And the city immediately, in the cases, the city terminated Brown just 1 hour and 15 minutes after being notified of the post. And then they put out a press release saying this thing happened and we fired. And like most of the public were like, what are you talking about? Who is this guy? What? Like no one knew about it. There was no furor. There was no nothing.
Creating their own disruption.
Yeah, they created the disruption. I mean, and like honestly, right? That's kind of what they do, right? Or like if I want to get somebody fired, all I got to do is follow. Let me just focus on them, follow their social media, find something offensive, try to stir up a shit show, and say, look, now the police department can't get anything done because we have protests every day because of this post that I publicized, and made an issue of. And meanwhile, you have a cop. Like in the Plainview Project, some of these guys posted really stupid stuff. Some was really offensive. Some of it was just dumb, and some of it was like people who worked for 20 years and did a great job. What they actually did at work was okay, right? But they get fired because someone shines a light on it. And you know what? That may not be fair, but that's the way it is. And that's what you got to remember. It doesn't matter. You can't say, well, I only posted it. I thought it was limited to my friends. You have to assume that every post you make is going to go viral. That's the mindset that you want to take if you're going to post something on social media. Now this guy, in Tulsa, he wasn't even a cop yet. They went back and we saw some of that in Plainview Project. These are really old posts. He sued and he won. And this one wasn't as close. And really what the court relied on, you said, okay, you're speaking as a private citizen about matters of public concern, which was that was a little weird. But when we looked for disruption, the court said there's no disruption here. There was no problem at all until you kind of decided to create disruption and immediately fire the guy. So, it really depends on what does the government do in response. And so, some things to think about this, right? It was narrow. It didn't go viral. He wasn't doxxed. There was no media circus. What if those things actually had taken place? What if that had happened? If there was media coverage of these posts and then it became a big thing and there were protests and it's the same post, right? He didn't do anything different, but might the outcome be the same under First Amendment analysis? And I think, the answer is probably the outcome, might be, different. But it was good for Tulsa. So employees 2, employers 1. All right, we got 3 more. Who's going to win? I got this next one. Melton versus City of Forest City. It's an 8th Circuit case. Now, these were decided last month. This is August 13th of 2025. This is, a federal circuit court in the 8th Circuit. First of all, let me just comment. City of Forest City is like my favorite category of place names where you have to say city twice. It's not just Forest City, right? It's the city of Forest. Right? City of Forest City. We're a city. We want you to know it. It's great. And the other comment with this, in some of these cases for the lawyers, a lot of times you read a decision. I read a decision and I know who's going to win first sentence in, right? You just know it, just because of the language that's used. And I just want to read the first line of this case. Stephen Melton is a pro-life evangelical Christian. In June of 2020, he reposted a black and white image on Facebook that depicted a silhouette of a baby in a womb with a rope around its neck. His intent was to convey that he was anti-abortion. Right? Did I say with like a soft voice there when I read it?
Very gentle.
Yeah, it was very gentle. So he posted this meme in June of 2020. Anything happening in June of 2020? Anything in the news in 2020? Right? So when all the Floyd anti-police stuff was like at its highest, this guy posts a meme, and you can Google the meme, Melton versus City of Forest City, and you can see the meme. Yeah, it's a silhouette of a baby in black and white. So it's a black fetus with a rope. Yeah, a rope, a noose around its neck. And then underneath it, in quotes, I can't breathe. right? Which is associated with George Floyd. And so, and it was the point, well, hey, this person was killed, but what about all these babies being, I mean, I'm not taking a position on any of the political issues there, but it's interesting how the court described the meme, and a different court could describe that meme very differently, and I would be able to predict the outcome. And in fact, we have another case where a court does the exact same thing in the opposite direction. But so Melton's not a police officer, a firefighter in Forest City, Arkansas. He posts this thing in June 20 as all of the Floyd stuff is happening. And, it's got this silhouette, it's got the noose, it's got I can't breathe. One of his retired supervisors, so one of the guys he knew from the department, sees it in his Facebook feed, and it says he complained to Melton. So he contacts Melton and says, "What are you doing?" Right? You idiot. Melton takes it down immediately. So we don't know exactly how long the post was up, but it wasn't up very long at all, right? He deletes the post. Okay, what happens? And this is where it doesn't matter how long you posted. It doesn't matter if it's your private Facebook group, any of that kind of stuff, right? Oh, wait, I have to change the case. It doesn't matter because it gets out there, because this post that he had up there for a couple hours, somehow somebody screenshots it and sends it to the mayor, right? And that's just how it works. The mayor gets it. The mayor's horrified, puts him on administrative leave. He cites the egregious nature of the post, and it provoked a huge firestorm. The firestorm, there's some record evidence that some police officers, some city council people, some people, had complained once somebody else kind of put it out there that this guy had a post that he had deleted. So whether it was a firestorm or not, I don't know, but the city certainly said, we're immediately putting you out of there because you're causing us, these problems. The case says that Melton filed a grievance, or they terminated him. Melton filed a grievance and he lost. That's all the case says about it, which is interesting. And there's nothing more about that. And we don't know, how that went, but he filed a grievance and he lost. He then sued in response. So he alleges First Amendment retaliation. He loses at the district court level and he gets up to the Eighth Circuit and he won, in the Eighth Circuit. So the Eighth Circuit applies the test. He's speaking as a private citizen. He's speaking on a matter of public concern, right? We have abortion issues, race issues, big issues, especially in 2020. So that triggered First Amendment protection. So now the court has to balance things. And, the court rejected the city's argument that there was a quote unquote firestorm. And the court called that evidence of disruption thin and really said, we don't see much disruption here. The fire department was still responding to calls. There's actually evidence that his coworkers all supported him. And what really happened here probably is you were offended, mayor or city council people, by what this person posted. You didn't like what he posted. That's why you acted, not because there was any disruption. And the court talks about this concept of this heckler's veto, they call it, right? So just because the majority of people in a town or whatever don't like what somebody says doesn't give them the ability to veto somebody's constitutional rights. I don't know how true that is in practice, but you'll see it mentioned in cases. So the court didn't buy what the mayor was saying. And the court reiterated that, you don't need actual disruption necessarily, but you have to show likely disruption and you can't just wave that wand. And the court, quote from the case, enough outsider complaints could prevent government employees from speaking on any controversial subject, right? Even on their own personal time. Here, there was no showing the Melton's post had an impact on the fire department itself. No current firefighter complained or confronted him about it, nor did any coworker or supervisor refuse to work with him. Right. So we have a court looking, it's all that disruption. Can you show it? And the court looked at this and said, didn't show it here. Look, pretty offensive post, but hey, he's got a right to say, something offensive. At least that's what this court in this circuit said for this firefighter in this case. So Melton wins. We are 4 cases in. The score is workers 3, government 1, which I think is pretty good. Now we've got 2 more left. I think I've got the next one, right? Yeah.
I think that's
the next one. All right. So we're going from Arkansas to Massachusetts. I already know how this is going to turn out. So, I literally know how it's going to turn out because I read the case. But all right. Same issue, right? An offensive, post or a post that somebody's offended by in June of 2020 in relation to what was going on in Floyd. Think about this. These are appellate court cases. it takes a couple years for these things to bubble up, and distance hopefully gives some perspective. And that's kind of part, by the way, that's part of the process. That's why we have appellate courts. That's why, we could get everybody in a room and get a decision issued really quickly, but as a society, I don't know that that's in our interest, right? Time does, and distance does help, I think, or it should. So we have this next case, Hussey versus City of Cambridge, decided the very same week of the Melton case. And so this is the First Circuit Court of Appeals. This case was decided August 15th of 2025. And so this is a police officer posting something. And let me read the first line, right? You can tell me, how do you think this is going to turn out? Here's the first line of the case. The details of the tragic death of George Floyd on May 25th, 2020 are well known. Floyd, a Minneapolis, Minnesota resident and father, went to a convenience store to buy cigarettes, right? I know who's winning this case. All right. Based on reading that. So what happened in February of 2021, right? Or in early 2021, Congress introduced, or some folks in Congress introduced the George Floyd Justice and Policing Act. Lots of fanfare in early February or late February of 2021. For those of you keeping score, it didn't go anywhere. It wasn't passed into law. That hasn't gone anywhere. But we have the George Floyd Justice and Policing Act. We have a police officer, Officer Hussey, that the very next day, right, gets a story related to the introduction of this law that he shares, and then he comments on his Facebook page. And here's his comment. He says, quote, "This is what it's come to, quote, honoring a career criminal, a thief, and a druggie. The future of this country is bleak at best." Quote. That was his post, right? And so you have this guy kind of saying, well, and in the investigation in the case, there's language in the decision where he had an opportunity to explain that a little bit, and whether it was what was really going on when he posted it or not. But he's saying, look, I'm all for police reform. This person was murdered. That was horrible. There are things we need to do to improve, but I think that, holding this person out as an example is insulting to me as a police officer, is essentially what he said. Right. And so looking at the person as opposed to the act or what happened to the person, think about Charlie Kirk. Right. And I don't mean to compare Charlie Kirk to George Floyd, but you have a person, right, who you may feel a certain way about, that something happened to that everybody agrees was inappropriate. And you're commenting on that person in response to this horrible thing. Right. And so there are some similarities here that we're seeing. We have somebody posting negatively about George Floyd. The language, pretty tame in terms of the stuff I've seen for social media, like a career criminal, a thief, and a druggie. He deletes the post a few hours after he shared it. And the record was like, nobody responded to it. He didn't get any. So he just took it down, not because he was worried about it, but he was just like, all right, no one wants to talk about this today. So another one just posted on his Facebook page, only up there for a few hours. And then sure enough, what happens? Somehow somebody gets a hold of it. Right. I mean, I promise you, people are going to get a hold of this stuff. So somebody gets a hold of it. The NAACP contacts the chief to complain about the posts. The department investigates it and they suspend him. Jesse, do you remember how long they suspended this guy?
4 days? Was it 4 days?
4 days. Yeah. I'll tell you, that's why he lost. There's some part of me where the judge is like, come on, man, 4 days. You should have just took it.
Right.
But that's not what the court, there's no line in the case that says, come on, man, you should have just took it. The court applied the standard, but he only got a 4-day suspension, and he sued. And so he lost the district court level, and then he appeals up to the circuit court, and the circuit court found that he did, speak as a private citizen. He did speak on a matter of public concern. So now we're going to balance. And we're going to look at, two sides, actually, not just the government's interest. The court starts off with the employee side. And I think this is one of the reasons why this case is interesting. Not all speech gets the same degree of protection, the court starts off with. So yes, you're speaking as a private citizen on a matter of public concern, but some things are a little more protected than other things. And so I'm going to quote from the decision, quote, "Speech on public issues applies the highest rung of hierarchy of First Amendment values and is entitled to special protection. However, we have recognized that speech commenting on public issues in a mocking, derogatory, and disparaging manner is accorded less weight in the balancing test. So if he had posted something that delivered the same message in a way that wasn't mocking or derogatory or whatever, he would be more protected. And the court goes on to talk about what, he stated, and they say, well, calling somebody they talk about druggie and how druggie is a bad. I'm like, druggie's pretty mild, honestly.
Mm-hmm.
But the court says, all right, I got a thumb on this side of the scale because what you said was kind of mocking and derogatory and doesn't get that much protection. Now let's look at the other side of the scale and disruption. And the court looks at this issue and first says, now we have another thumb that we're going to put on the other side of the scale, because when the employer, the government employer, is a law enforcement agency, they're going to have a greater interest in avoiding disruption because you need trust and discipline, right, in that context. So they don't need to show actual disruption, just potential to disrupt. And here, the relationship that they identified was the relationship with the public. And so these kind of comments, and specifically these comments by Hussey, undermine the police department's relationship and trust with the public. And I hear where they're coming from. Okay. And I think that was argued the right way. I don't know how that's different from a heckler's veto, honestly, if people are calling and saying we don't like it. But the court applies the test and ultimately applies that in favor of the city of Cambridge. So Hussey loses. Interesting decision there. I will say that there is a vigorous dissent, in that case, that's worth reading, kind of talking about some of the thumbs on the scales, but this one goes against the officer. So, all right, it's 3-2, third period. We've got the last case, and this one comes out of the Seventh Circuit. Correct, Jessica?
That's right, Rick. Right, Hedgepath versus Britain came out in the same time frame as the last two cases we've been talking about. This one's August 26, 2025, but out of the Seventh Circuit. We're sort of back in Illinois for this case, although our plaintiff takes a vacation to Florida, and that's where the trouble starts. So I guess we're hitting Illinois and Florida in this one.
She's drinking?
What's that?
On vacation. She's down on vacation, and there's a lot of Facebook posts.
Sure. And I'm going to continue with the trend of, you can tell from this line in the case the way this is going to go. Here's the first line. Jeannie Hedgepath, a high school teacher with 2 suspensions and prior warnings of possible termination, posted inflammatory messages to a Facebook account, followed mostly by former students. The posts prompted numerous complaints and media inquiries to the school district. Given the disruption and previous warnings, the school district fired Hedgepath. And they haven't told you what they're going to do, but they've told you what they're going to do, right?
You're going to lose.
You're going to lose. So she was an Illinois high school teacher, and she went on vacation in 2020, right? We've already talked about what was going on in May, June 2020, a lot, right? We've got BLM protests in the wake of George Floyd's murder. Hedgepath goes on vacation to Florida. She doesn't say this in the case, but I imagine she was maybe sitting seaside with a cocktail, and then she gets on Facebook, where she has, a lot of friends, let me just say, 800. Pretty good number. Unfortunately for her, 80% of them were former students of hers.
Yeah.
She made a point of arguing in her case, right? She had a policy of not friending current students. As though that was going to be significant here. Well, it wasn't. Spoiler alert. Here are some of the things that she did while on vacation, sipping her cocktail, I imagine. She's commenting, I want to move because the Civil War has started. And she's conversing with someone she's Facebook friends with, and she jokes about needing a gun and training. She's referencing the protests, right? Mm-hmm. And then at one point, and I think this was some of the more concerning and even more inflammatory language. She posted something, want to stop the riots? Mobilize the septic tank trucks, put a pressure cannon on them, hose them down the end. You think this would work? And in addition to that, she got into a back and forth with a former student. So because she's posting all these things, it's attracting attention, of course. And in the course of that back and forth with the former students, she says to them that she finds the term white privilege just as racist as the N-word.
Yeah.
And the court, notes that this was a diverse student body that she taught at the high school. And even though she had this lovely policy of having privacy settings on Facebook and didn't identify herself as an employee of the district, they were all former students of hers. And so, of course, word got around very, very quickly. And the school district was barraged with complaints, not just from the angry public, right? But current students, parents of current students, media inquiries from some pretty significant media outlets, I think, including like the New York Post. It wasn't just like local newspapers.
Yeah, she kind of went, she didn't go viral, but she got close to going viral, I would say, right?
It was, bad enough that the school board had to issue a press release, making clear that those were not the board's views. Then they had a board meeting. 58 people came to speak. And she, the dust settles and she ends up fired. And just a quick note, since the court mentions it in their opening, right? And they mention it again when they're balancing all of this and looking at the level of disruption. They mention this past discipline she has, right? Just like the court in Noble felt the need to remind us several times that the library security guard had a clean record and no issues at work. This woman had issues at work, although they don't tell you, but the issue she had at work didn't have to do with off-duty social media comments and didn't have anything to do with potential First Amendment concerns. She had sworn in class and used colorful language a couple of times. Nothing that looked too out of the way. I think she told somebody to, reopen your fucking book and read the fucking chapter at one point. She appropriately got disciplined for that, but that's not what we're talking about happening here. But they relied on that, right, in making the decision to discharge her. I don't think we see anything in the case about whether she had filed. We don't see anything about a grievance being filed.
No mention. And normally you wouldn't see mention. I'm surprised that there was mention in some of the other decisions about that.
Mm-hmm. So here, the emphasis, on review, right? These are ultimately matters of public concern that she's commenting on as a private citizen. All right. It doesn't matter how offensive or inflammatory the speech might be. It's protected speech, except when we get to the balancing test, they emphasize she is a teacher. She's similar to the way that law enforcement officers are described in the other decisions we've talked about. There's a public trust. This is a public facing position. And so there's a greater likelihood of disruption. And here, oh my gosh, was there disruption? And in fact, the court takes the time to distinguish from the Melton decision, the firefighter that Rick was talking about, and say, look, in that case, no firefighters complained. Here we have the opposite. Everybody's complaining, not just the angry mob and the public, but everybody connected to this in every way, shape, and form has been upset. And we don't care, teacher Hedgepath, that you had a couple of people say they support your free speech rights or they agree with your viewpoints, write letters or show up for you. That's not what it's about. The district produced a, quote, wealth of undisputed evidence of actual disruption, end quote, caused by the posts. And oddly enough, and I'm not sure I agree as a legal matter, but the court found it relevant to the disruptiveness and the weighing of the scale that she had passed discipline for cursing in the classroom in front of the student.
Yeah.
Right? Which was odd because
I agree.
That evidence of disruption that's relevant here to this analysis, right, Rick?
No, it's not. It shouldn't be relevant at all. Now, in a termination grievance, absolutely, if we're applying just cause standards, for sure. But I don't see any place for it here. And I think I'm not surprised by the outcome of this case, and I don't know that I disagree with the outcome of this case. But I think the standard is supposed to be, you're not supposed to discipline somebody just because you don't like what they said, right? I disagree with what they said, but it's all, I think it would also apply that. And I also don't happen to like her. We don't like this person. She's not a good employee. And then she said something, which I think kind of, begs the question of, well, if she was a really good employee and she said this, would they have done something different? And how does that matter? How would that matter? How could that possibly matter? I don't know, but she loses, and we end up with a 3-3 tie, and there's no shootout. This is it. We're just going to end with a tie, which is good, right? We're going to keep it balanced. And the other interesting thing in that case, in these 3 cases that we discussed, they're all from August. They'll probably be in like the November newsletter for folks who get the newsletter, premium subscribers. They're all talking to each other, the circuit courts, and especially this one, since it's the most recent one. They're talking about the 2 ones after Melton feel the need to comment on Melton, and so these things are happening in real time. And so I think if you think about, these are George Floyd related, 2020 related things that have taken 5 years to get to the circuit court level. It'll probably be the same thing with Charlie Kirk's stuff. So in 2030, there'll probably be circuit courts issuing decisions on these things. And so, I don't know, what kind of takeaways do you think, what do we make of all this, Jessica? I mean, what are we going to do?
I think that the social media paradigm for disruptiveness is really interesting, because on the one hand, when you comment in what is now our public square for comments, you are, you're helping yourself, right, on that, establish that your speech is on a matter of public concern, right? And the more people that talk about it or comment or react, just emphasizes and underscores that it is a matter of, what you're talking about is a matter of public concern. It's not just a personal gripe. On the other hand, the reach of social media makes disruption all the more likely, one way or another, whether you go viral or the people that see your speech are linked to your employment in some way, or they're able to communicate with your employer. So it's sort of a double-edged sword in terms of the test.
Yeah, I think it is. And I think that it's such a mean-spirited, every discussion is a mean-spirited discussion, I feel like, on social media. And it seems like it keeps getting meaner and meaner. And, the people, the groups, right. And there are well-funded groups on both spectrums, right. And that what's really interesting with the Kirk thing is that, for a few years, it would be the cancel culture stuff was coming from the left. And now I feel like it's coming from the right. And again, I don't, my opinions on any of these things, I'm not sure that I even care about my opinions about any of these things, right? Nobody else should, but it's interesting to see, some of the, honestly, like the hypocrisy, because it all boils down to, I'm all for free speech until somebody says something I disagree with. And, that's not the way it's supposed to work, but that's the reality. And so if I want to, and it could be, the pendulum could swing back to the other side, but what's clear to me is these groups know what they're doing. And they know if you can create a public furor, that's going to cause disruption, or a likelihood of disruption. And so you can pretty much not only pressure an employer to fire a public employer, even to fire somebody, but you can create enough of a firestorm that you could ensure that termination, or make it more likely that termination would hold up, if challenged on constitutional grounds. And it's just going to get more and more sophisticated. And so, yeah, I mean, listen, I wouldn't be on, if you're a police officer or a firefighter or a correctional officer, we teach about this at the seminars. Do you really have to post it? I mean, do you really have to post it? And if it's hey, we have a staffing issue, or we've got, there are some things that are different, but do you really have to post something controversial? I'd really think long and hard, and maybe we can win, 5 years later, maybe not, but it's such a crazy environment out there. I'm not sure that it's worth it.
And
I think it's kind of a sad message, actually.
It is sad. And these courts, to a certain extent, they talk about the heckler's veto not being the deciding factor, right? But much of these decisions center around the strength or the lack of public reaction to the speech. And I don't know whether that should be the standard when we think about disruption, but that is the way it's trending. And to your point, Rick, about we have a lot more ways, and it's a lot easier and a lot quicker technologically to create that firestorm than it used to be. Yep. Then you're putting that pressure on an employer really quickly. And I think one of the other takeaways here is it really depends on the job you have, right? That's how a lot of these cases turn out. What do you do for a living? If you're a cop, the cases weren't trending trending well for us on the employee side, because there's that public trust element. And we saw in the Hegpeth case, teachers, I think, viewed similarly.
Yeah, that same view is going to be, so police officers, firefighters, correctional officers, but I would say probably in that order, in terms of the degree to which the public kind of cares, for whatever reason about the things, people really, things that police officers and teachers do, people care very deeply about. And, so you have less leeway. Does that mean your constitutional rights are not as strong as the sanitation worker when it comes to speech? Yes, is actually the answer. So if you want to change that, good luck and God bless. And, maybe we can, change that somehow. But I think it's more important to know it, to know that. And for the union folks who are listening, to just try, to educate your folks on these things and keep them off social media if you can. But if not, but I mean, look, the reasonable people will take the advice. I'm not worried about what the reasonable people post on Facebook, and that's the problem, right? So there's always going to be these cases, and we'll just kind of try to keep you informed and do the best you can, with your members. And this was an interesting discussion. Jessica, thank you so much for joining us. Is there anything else that you'd like that we should keep in mind?
No, I think you nailed all the key points. Like, be careful what you post on social media, if you post anything at all. Otherwise, you'd be seeing someone like me, maybe at your labor arbitration, and it's never fun having to explain to a room full of people what you meant long after the fact. So that's, I guess, my final comment. Thank you for having me.
Employers, it's never fun to see Jessica in an arbitration either. So, and Jessica, are you going to join us? Are you going to run the strip, in November, or when you're out there in Vegas? We'd like to go and run in the morning. So
I'm up for a run.
All right, Jessica, if anyone's coming in November, we'll probably go for a run Thursday morning or something. So, sign up. If you want to come out and see us, check us out, lrs.com/seminars. Thanks a million, everybody, for joining. Have a great month. I'll talk to you in November. All right. Bye.